Mr. Then it goes. NCT remains confined to the NCT Act. Then your argument then.
No, my lords, I showed reference to the RTE under 12A.
Our argument is one of the
Oh, my friend has also
same argument is not different. My argument is 23-1, my lord.
I am arguing 23. I am not going away from 23.
Your submission was that none of the baggages of NCT Act
Yes.
carried.
Yes.
and now argument is being made.
It's the same argument, my lords. I'm not making any difference.
But I made my submission.
My lords, I'm not going away from anyone's argument, neither Mr. Singhvi's argument at all. I am showing how the scheme of the NCTE Act operates. I'm just showing that. NCTE Act I have shown in 12A itself refers to the RTE. Now I'm coming to an RTE. Please give me a moment. Just give me a moment. Now, my lords, what I'm trying to show here is that 23/8/2000 notification had come when 12A was not in existence. It came in by an amendment later on. After the amendment, the NCTE passed a notification in 2014, that is 12/11/2014. And that was passed following the procedure under section 32 and 33 by placing it on the floor of the parliament, and thereafter the notification had been issued. Now, present part of this particular notification, and that's an added challenge that I'm making to the procedural lapses there, it has never been placed before the parliament, and that's noticed in the issues that have been framed before the Honorable High Court also. So please take, my lords, I have just passed on that to my lords.
What was the amendment? What was it?
Yes, my lords, I'll just show. Please come.
What are they passing on? They have not raised any of this in the High Court. I have no problem about it. I'll meet it. But I mean, it's a free for all now. Let's give a copy. If somebody had raised it, government would have replied to it. Just like I mean, now all contradictions.
This is all dealt by High Court also.
My lords, I'll show it from the judgment. The High Court notes this.
What was the?
These are the regulations framed under 12A, wherein for primary school they say the qualification would be what is provided under RTA 2009.
Correct.
These are the regulations under 12A. Kindly see, my lords.
My lords may just come to the regulations. My lords have, what is this page number? Page 6, my lords, on the top. 2014 regulation. My lords have page 6 there. Subject regulation number 2 of regulation 4, NCTE determination of minimum qualifications for persons to be recruited as education teachers in pre-primary, primary, upper primary, secondary, so and so. Now please look at preschool, nursery, and then, my lords, followed by 3, primary and upper primary. And just please see that minimum qualification as laid down.
The first schedule.
My lords, page 6, my lords, internal running page 6. I'm sorry. Justice Zulia has that?
Yeah. Primary and upper.
Please, my lords. So, my lords, this was placed before the parliament. Now, if anything had to be amended, it was actually this notification that required an amendment because 12A had come into effect. And this has been issued subsequently. It may reaffirm that the minimum qualifications laid down by National Council in 23/8 as amended from time to time issued in exercise of powers conferred under 23/1. But what would have to be then dealt with would also be this and placed before the floor of the parliament. Because we are changing now the minimum qualification. And this is as per RT Act 2009. This is what is saying is also. that so far as the RT Act is concerned, it deals with only primary and upper primary. Reference to the RTE Act has been made under 12A. It is also made here in this particular notification. My lords, may please read that once again with me. It says, as amended from time to time in exercise of powers conferred under subsection 1 of section 23 of the RTE Act 2009. Now, clearly, RTE Act in context of the NCTE statute is the special statute. And NCTE Act becomes a general statute in that sense. So, therefore, these powers are exercised.
Special general again is a very confusing way to deal with statute. Something is special for something and
My lord, yes. My lords, yes, we had that thing on the sick industrial companies and the Companies Act and all of that. We've done that in the past. But if I
given situation which shall prevail, we can. I think based down to interpreting provisions of the act
rather than
general categorization.
I got it. My lords, I take that.
So,
but then one thing that we note everywhere is that the NCTE Act recognizes that so far as primary and upper primary is concerned, it is formulating those qualifications for the purposes and taking its thing from the RTE Act. That is what Dr. Singhvi has argued, and I have no this thing. I'm not at all digressing from that particular procedure at all. I am only that even when you do that exercise, there is a procedure that is prescribed under the Act, and that procedure is required to be followed, is what I am emphasizing on. My lords, I hope I make myself clear there. And that is the procedure that was followed in 2014 when this present notification was issued. Now, this 2014 notification at best is the amendment also to the 23rd of August 2010 notification. So, therefore, if any modifications had to be done, it had to be to this notification and not to the 23/8/2010. Be that as it may, my lords, in this context, I wanted to place here the one judgment that's to wrap up this particular argument by one judgment that A. Manoharan. My lords will find the judgment of this Honorable Court in A. Manoharan versus Union of India. My lords, it's in the volume 3 of the compilation.
what is the ratio?
My lords, the ratio here was that when there is an expert body that is constituted to carry out, make the rules and regulations, and no power is reserved to the government itself. And the words of that policy, as is in 29, are identical in that Board of Court of Trust judgment. Identical. And there they said, you have given this power, there is no power that is left. My lords, volume 3, my lords will find it at page number 568.
Volume 3.
Volume 3 of this convenience volume.
Volume. Sorry, volume. Volume to the page.
Page 567.
Page?
My lords, it will be in my lords volume at page 568. I'm reading from my previous volume, my lords, because that was my marked copy, but I will bring my lords to the relevant paragraph numbers of it.
Sinner's judgment, Justice Sinner's judgment.
Yes, my lord.
Find entire body of authorities on this.
Yes, my lords are right, absolutely. So, my lords, may I just show the facts in just one paragraph? If my lords may turn to paragraph number 3. Just the last few lines of paragraph number 3, and the relevant one to the extent that I'm going to be placing is going to be paragraph number 16 there, which will have the identical provision just above that is worded there. My lords, paragraph number 3, Madras Port Trust employees appointment promotion rules, regulations were made under section 28 of the 1963 Act. They were amended in the year 2000 by way of a regulation. Regulation 5 read with the schedule thereof provides that insofar as appointment to the post of executive engineer is concerned, possession of a civil engineering is imperative. It was amended with the approval of the central government in terms of subsection 1 of 124 of 163. Regulations therefore have statutory force Gazette, not only the approval of the central government was obtained, but they were also laid before both the houses of the parliament. So the issue was the degree of the civil engineering degree of the engineer. Now, my lords, please come to paragraph number 16 here. My lords have that? Section 111. Let's open paragraph 16. Page number 584, my lords. Have that? May I read that? Yeah. Section 111 of the Act confers power on the central government to issue directions to the board must be examined in the backdrop of the aforesaid statutory provision. It reads as under. Without prejudice to the foregoing provisions of this chapter, the authority and every board shall in discharge of its function under this Act be bound by such directions on the questions of policy as the central government may give in writing from time to time, provided that the authority of the board, as the case may be, shall be given an opportunity to express its views. So and so, decision of the government, whether it's a question one of the policy or not, shall be final. But more or less absolutely similarly worded as our section 29 of the NCTE Act. Now, please come down to paragraph 18 and paragraph 20, and the High Court also notes this judgment and sides with the proof. The board, however, has been conferred with the power to make regulations under section 123 in regard to matters specified therein. Section 123A of 1963 Act empowers the authority to make regulations consistent with the provisions of 1963 Act inter alia for purpose of salaries, allowances payable to, and other conditions of service of officers and employees of the authority under subsection 2 of 47 of the 63 Act. Now, my lord, please come to paragraph 20 now. Powers of the central government to direct any board to make any regulation is confined to the matters specified in section 28 or 76 or 123, or to amend any regulation within such period as the central government may specify in this behalf. Section 34 of our Act. It said in 2 years, you can make any amendment, central government can direct. No regulation exists enabling the government to issue any direction in relation to a regulation governing salaries, allowances payable to, or any other conditions of the service of the officer and employees of the authority. In any event, in the event of such direction is not followed, central government may take recourse only to the provision of subsection 2 of section 124 of 163 Act, which reads that no regulation other than the regulation made under 28 be approved by the central government unless the same has been published by the court. So the same thing as is in the present case. It will go before the parliament. The parliament can then make the modifications. Here, the central government would follow the procedure that it had in its own statute. Now, my lords, please come to paragraph 24. The power of the central government to issue directions as contained in 111 cannot be stretched to amend regulations. Powers must be exercised by central government only in regard to administration of the trust. Such power to issue direction must be construed strictly. So, my lords, I don't think there can be a judgment that could have a closer provision similar to 29 to that extent. And I respectfully submit that if 24 is the principle that this court applied to that interpretation, then central government definitely could not have issued that direction. Now coming to 23 of the RTE Act after this. Now, my lords, if we may turn for a moment to section 23 of the RTE Act. My lords, it's in that same convenience volume, if my lords would like to use that. Yes, in that same volume 1, the first volume. I can see Justice Julia is using the book rather. Now, my lords, 23, I will, for the convenience of the court, Code divided actually into two parts. The first part, under 23, is academic authority has to take the decision in making the prescribing the qualification or making persons who will be eligible. So let's please read it once, and I'm sure my lords have read it many a time. Any person possessing such minimum qualification now, comma, as laid down by an academic authority, comma, authorized by the central government. So what? Minimum qualification prescribed by an academic authority, authorized by a central government. Now the academic authority is that executive council under the NCTE Act. So it's not the central government that has the power to do so under even 23(1). It is that academic authority which has been authorized by a statute to formulate, determine the qualifications by a notification for those persons eligible for appointment as teachers. Therefore, there is no power with the central government that is retained here. That power is with that academic authority. Now, my lords, I come to the second limb. And the two limbs are independent, divergent. They do not have an interplay at all. What is sought to be done today is to try to bring one part from 23(2) and take it to 23(1). That is what is sought to be said. The central government exercise power under 23(1), which I submit they cannot do on the plain reading, and take some part from 23(2), which also cannot be done. I'm just explaining why I say that.
Here you are merging with Mr. Singhvi's argument.
Well, I am not at all in digress with Ms. Dr. Singhvi's argument. I'm not going to at all digress. A moment saying that I'm in conflict or I have a different position than
Right now you are not in conflict. Right?
I am not. Well, I'll try my best not to be in a conflict. On the same side, we should not be in a conflict in any case. So, well, we may put it differently, but I may make myself with a caveat here that if I'm not very articulate, I'm not being in conflict. So please don't take it in that manner. I'm putting that caveat right there. Now, my lords, can I come to the second limb of 23 and how I read it, if I may seek to impress. Where a state does not have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, central government may. Now here, there is some power retained with the central government, but subject to those above caveats. If the state does not have adequate institutions which offer courses, or it does not have training teachers, education, or it does not have enough teachers who possess that particular qualification, there, central government may, if it is deemed necessary, by notification, relax minimum qualification required for appointment as teacher for such period not exceeding 5 years as may be specified in that notification. So, minimum qualification can only be prescribed by the academic authority authorized by the central government. Central government is nowhere in that area of a specialized body. But what the central government under 2 retains to itself, subject to those 3 preconditions. In subsection 2 of 23, it may relax the minimum qualifications for appointment for a period not exceeding 5 years. And there also, my lords, it has provided that they will have to acquire that minimum qualification in that period of 5 years.
They're saying they'll do it in 2 years.
My lords, I am now, let me answer. This is exactly what I am answering here. For First of all, this is their case before the High Court, and throughout have been we've exercised the power under 23(1). It is not their case that the power has been exercised under 23(2). And this is what I'm trying to draw that attention of my lords, that we cannot mix the two powers of 23(1) and 23(2). 23(2) operates in a different area. 23(1) is entirely a different power, exercised by a different entity. And to exercise 23(2), government will have to show that the conditions precedent are present. You do not have educational institutions giving teacher the trainings. You do not have minimum number of teachers which are available. In that circumstances, you may do so, not otherwise. And then you will give 5 years time to enable them to acquire that. But where is that situation? What is the situation in the current case? The Honorable Minister says, I believe B.Ed is a higher qualification. They are better qualified. The MHRD writes in its letter it's a higher education. It does not say that its power is being exercised in the realm of 23(2). So it is nobody's case on the other side that it is 23(2) that has been exercised. Now, my lords, how do we go about mixing up the relaxation of a qualification? Take one small part out of 23(2). That is, we said 2 years. You do a bridge course. When 23(2) operates as a stream in a given circumstance and differently. But my lords, may I just proceed to read, because the second proviso comes by an amendment in 2015. So may I please read this for my lord's benefit? And so if you had to exercise, there was, my lords, just relax minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in the notification, provided that a teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. So the statute itself gives the time of 5 years from the commencement of the act. Now, my lords, in 2015, this further extension to acquire the qualification was brought in by an amendment. And that period is also over.
This is not applicable in this case.
It's not applicable.
Because this is for in-house teacher.
Yes. Now, my lords, I
refer to this.
Absolutely. So, my lords, therefore, my submission is this for my lords' consideration. 23(2) operates in 1 and 2 operate in 2 different realms altogether. 23(1) is fixing of an eligibility by an academic authority, no power reserved to the central government. That's my first submission. So far as 23(2) is concerned, certain power has been reserved to the central government to relax the minimum qualification, the preconditions case of the present petitioners before my lord, that the precondition under 23(2) is existing. Neither is it the case written in the letter of MHRD or, for that matter, the letter of the minister.
No, subsection 2
Yes, my lord.
gives power to the central government
Yes.
to relax those conditions for a period of 5 years old.
Yes, my lord. Yes, absolutely. I'm ready.
So, after, when was this notified? Let's say 2010.
Yes, my lord.
So, beyond 2015, is it your case that central government had no power to relax it?
My lords, they could not have done that because that is over, that period is over. But
Therefore, there is
Therefore, there is-
being brought.
I was reading the third proviso. Please, that is what I was going to read, my lords. I said that they have given that further. They have done it by way of a further proviso. Please come to that.
That's from the amendment.
Yes, my lords, please come to provide it further.
No, that is for the teachers who are already there,
Who are in service
who is
teacher.
appointed.
Yes.
Between 10 to 15. Even between 10 to 15, when the Act came in 2009, relaxations were provided and those were continuing till 2015. For them, the last extended period is 4 years.
After that, there is nothing.
relaxations were provided in various states.
Provided further that every teacher appointed
or in position.
as on 31st March. This amendment comes into force on 1st of April, a day after. So these teachers, this is for those teachers who are already there.
So for that,
This relaxation for 4 years in 2017 means till 21.
My losses came in 20.
It will extend for 4 years, counting from 17.
My lords, can my lords look at the footnote? It is with effect from 1st April 2015.
Then,
So it will, my lords, get over in 2019.
all right, 19, whatever it is.
Whatever it be, the period is over today. The issue is that the period is today over in any case.
No, no, it-
But my lords put a question to me.
no,
That is it a case that
for future, then it is not over when the notification had come, which is this, in this case, it came in 2018.
my lords,
If this relaxation is also
my lords,
available
this is
for fresh recruitment, then it
this
would-
cannot be for the fresh recruitment number one.
Ah,
This is for those people only who are in service
so where,
as on. So this does not have any application.
so why are we going time? This doesn't apply.
I am not on that aspect. My lords put a question to me. I am on slightly different part aspect. I am saying that even if central government had to exercise any power, it had to satisfy the first three preconditions. 23 preconditions.
Just state-wise.
Statewide. State should have come. And there we have five.
But they have said state has come, Uttarakhand has come.
My lords, then it could be for Uttarakhand.
Then they said KBN also,
My lords,
Kendriya Vidyalaya is everywhere.
Kendriya Vidyalaya, then for Kendriya Vidyalaya, but not for every state. Not for every state. Not an omnibus notification applicable to all
The
states.
Secretary of NCT said only 40% vacancies available all over.
My lords, here it's come on record that you have how much? 3.5 lakh. 3.5 lakh for 19,000 vacancies. That submission
Yes.
that you have, the states would have to satisfy, or the entity would have to satisfy that they do not have the educational institutions or they have a shortage of qualified teachers. There are guidelines that have been issued by MHRD on 8th of November 2010. My lords will find them at page.
That are we concerned here right now?
No, my lords are not concerned here, but what I'm trying to submit is that 23.2 has a prerequisite requirement, a goalpost to be passed before the central government can exercise that power. And how that has to be done,
There is some data, some objective.
there has to be, and they have prescribed what is it that you will give to central government for the central government to consider that. If I can just very briefly show that, page 59, and there is a kind of a tabular chart that the states will have to provide, which my lords will find at 64, in the same very convenience compilation, number 1. So MHRD is conscious about that. And it's the same convenience volume.
Yes. You are saying whether shortage or not, there is a provision.
Only where there is a shortage of
Which page?
page 59. It's like an exigency of shortage of number of teachers available because there are no institutes, etc. You may only and only in that circumstance relax it. So, my lords, these are guidelines under 35(1) of the RTE for implementation of provisions of 23(2). Now, my lords, there is a full thing here, a tabular chart, how the applications would be made. Please turn to page number 63. My lords, format for seeking relaxation under 23(2). My lords have that at page 63. Take note of that.
But so what does the shortage mean?
The shortage would mean that a particular state does not have enough enough number of teachers who possess that qualification under 23(1).
Diploma.
Yes, a diploma, D-led qualification. If a state does not have maybe enough institutions that give that particular education or colleges that provide that education, or overall it does not have as many number of teachers as there may be vacancies at that given point in time, the state can, in this particular prescribed format, approach the central government and ask for a relaxation of that minimum eligible standards. Now that will have to be done in that particular exigency, the precondition of 23(2) being met. In the present case, it is noticed by the High Court that against an advertisement of 19,000 odd vacancies, 350,000 candidates with D-led are available. So the question of diluting or applying 23(2) does not arise.
Okay, anything else?
My lords, just one small part that is left over, I'll just quickly wrap up. My lords, the three judgments of this, two of this Honorable Court and one of Bombay High Court, my lords are completely familiar. My lords have said that yes, the fact that B.Ed is not a higher education.
We need not refer on that.
My lords, the judgments are in my lords' computation. I would only request one thing.
They have also been referred by the Rajasthan High Court.
They have been referred by the Rajasthan High Court, but that Bombay full bench judgment, which happened upon a reference because there was a divergence of view, actually sets out a complete chart to show how D-led is a special education that we are accepting.
Agree. That submission is there.
Yes. Now, my lords, my submission is here that if we allow,
Now you can give us a short note.
I will give my short note. I'll put it out. My lords, is just one very small thing left. I won't dilate. I'm not going to take my lords to the judgment since my lords say that that's not necessary. Now, my lords, just quickly coming to the next. Now, if this present situation is allowed, where B.Ed stated to be higher education, which it is not, then what happens is that it will be a violation of 23. Because then the teachers who do not have that qualification set up by the academic authority will be allowed to give education to children, and it's an admitted position. Coupled with the fact that if you say do a bridge course in 2 years, you admit that they do not have the qualification. Now I come to the last limb of my submission, which is
All this, the Rajasthan High Court actually has not followed, right?
Yes.
Rajasthan High Court has only taken a view that whether you have powers under 23(1), this, that's all. What kind of a course is
that is
what was the purpose
the pedagogical study.
What was the purpose of Right to Education Act? What meaningful education? You see the right, whether the focus has to be to give appointment.
I get you.
All that has not been dealt
That
with.
that was there before the High Court. Those all issues were framed. These were the questions which were framed, though not right, not answered. That is fine. But these were raised.
My lords, those were argued, and I will show it from that page. My lords,
No point if you are argued and not recorded, then you have to go back to
no, my lords, I have succeeded. I need not go back because my lords have held that if I succeeded on one point, I don't have to
Let us
go back on that. Now, my lords, I'm just quickly coming to the last limb of my argument, and that is bridge course, which is now prescribed by them to say, they're saying do a bridge course,
Not framed till date.
which is not being framed, of course, till date. There is no bridge course. It was admitted yesterday. And zone of consideration versus eligibility. Eligibility is in 23(1), prescribed by the academic authority. What is sought to be done under 23(2) today, which is not done under 23(2), but even if I say under 23(1), is an expansion of a zone of consideration, of enhancing the number of eligible persons by treating the B.Ed to be eligible. My lords, even if something like this had to be done, I ask myself the very first test what it it would be. Even if the zone of consideration or the eligibility is to be relaxed, it cannot be done ex post facto to say that you will be eligible, but you can acquire a qualification later on, which qualification till today has not seen the light of the day because there is no bridge course as the day. At best, if there was already a bridge course and a B.Ed candidate had done that particular bridge course and acquired that pedagogical qualification under that bridge course, they could have been eligible and the zone of consideration could have been enlarged. But for it to be put that you are already in the zone of consideration, you participate in the examination and you acquire your qualification later on,
That's it.
that is basically my argument.
Only 5 minutes. The lordships have put us a query that if the NCT, minus only 5 minutes to add to this, the lordships have put us a query if the NCT would have done this, then whether it would have been justified. Now, Manas, in that sense, we have raised this issue when the writ petition was filed, the NCT notification was challenged and is being dealt with under in reference to Article 21A. The right to quality education read with Article 14 and 16 in reference to public employment. Now, Manas, the stakeholders involved under the NCT Act is the central government. The states being the representatives, the experts being there. There is a mechanism provided for deliberations and discussions thereafter. So, what I'm submitting is,
Mr. Simple, yes, Mr.
what I'm submitting is that the child
have this going on.
I am item number 28.11 and 28.1.
You are Rajasthan.
No, I am from the candidates who belongs from the Bihar and UP below.
The first we have Bengal. Let's have Bengal.
You are Bengal.
Just submit the
Kamala, I will be very concise for your lordships in making my submissions because broadly or minutely, all of the points are being covered of ours.
What is left?
Now, the deliverance your lordships will find. The while power was exercised by the NCT under Section 23 of the TE Act, well, they have not taken into consideration.
This is a challenge to a separate interim order after a year. Let's hear it. Your Lordship may conclude Rajasthan and then hear it. Just a minute.
They have not considered.
Rajasthan is concluded.
Interim order has been have followed in toto the
But
Rajasthan.
interim order says it will abide by
It has followed Ram Charan Maurya. It has followed Ram Charan Maurya.
Yes.
Not right. That's another matter. This is number 28.13.
sorry, I missed it up. Ram Charan Maurya has a specific paragraph that notes that there was no challenge to the notification.
Kindly give that in the note.
I will put that down, but I want to point
We know that there is no
there
challenge.
is a specific noting in the judgment that there was no challenge.
Yes.
Now, your losses, if your losses kindly come to the SLP Malot, petition Malot 28.13, that one, page 107. What is the situation prevailing in the state of West Bengal? I have Malot stated throughout in Malot the petition, paragraph 38 and 39.
28.13 is Bengal.
Bengal. SLP number 22923. 22923 of 2022.
We are actually opposing him a lot. We have no copy of his petition and we are not appearing. I don't know who's appearing.
Look, the Board of Primary Education there, this is factual, and how it affects both.
As notice issued and served.
Yes. Now, just kindly consider paragraph 38 and 39 and just read out your losses. It is pertinent to point out at present that in the state of West Bengal, there are 619 primary schools, 690. And out of 619 primary schools, only 33 primary schools are comprising of classes 1 to 5 and the rest are comprising from classes 1 to 4. In West Bengal, Malak, the primary or elementary education comprises from class 1 to 4, not 5, rather than the state of West Bengal throughout the country. Now, in West Bengal, primary education consists of classes 1 to 4, upper primary education consists of classes 5 to 8, secondary education consists of classes 9 and 10, and higher secondary education consists of 11 and 12.
Right.
Then you will see paragraph 39. The petitioner states that as per the information collected by the petitioners, there are 642 primary teacher institutions having the total intake of 45,350 students for the session 29-21. You must pause here for a moment. This situation has come up when the DLED was introduced. Diploma in Elementary Education as a specialized training qualification was introduced.
According to you, there are more teacher schools than normal schools.
Normal, Malad, there are. Then your losses, approximately 250,000 number of DLED candidates.
Shall we proceed that additional point is in West Bengal there is no shortage of
DLED candidates.
DLED candidates.
If this is so, your losses, while the central government, not Malad, but they are passing direction upon the NCT to pass a notification under Section 23. Malad, these Malad, objectives of the states, the different states were not considered. They were considered, Malad, only the KPS schools across them.
We shall consider that.
That's your losses. Therefore, the exercise of power was not proper. This is against the objectives of the and the scheme of both the acts. Therefore, your losses, the next your losses will find page 137. But 137, I'm telling you, losses, we added the notification also. But the approach was made basically by the Kendriya Vidyalayas to the central government and then NCT. Now, kindly see, the Kendriya Vidyalaya IIT Kharagpur in 21-22 has notification for recruitment of teachers dividing B.Ed candidates specifically. Kindly, this is the state prevailing in the state. They divide the B.Ed candidates and say this is only confined to the only DLED candidates. This is very material. Kindly look at your losses, this notification.
We won't go into that detail.
I tell you losses why this is necessary. Just for a moment. Because this shows that DLED candidates were sufficient.
That's what I'm saying.
Therefore, the approach.
The other statistics you gave, we are satisfied that they are sufficient.
Therefore, what the net.
Any other point on that? Because the interpretation of an interplay of these two acts have been argued threadbare.
That's it. That's the only thing I'm saying, your losses.
You have anything to submit?
That's the only one thing to add. But whenever the power to determine qualification for appointment has been vested with the specialized academic authority, this is interlinked with the training qualification. I will collect the losses. Now, one will be determination of recruitment for a primary teacher. When the qualification is determined, one has to assess what would be the qualifications. Here, DLED.
That's 23-1.
23
and that
these are all that I'm trying to say, these are interlinked. The qualification and the training qualification. Determination of qualification for appointment and the training qualification.
training
Training, this is a specialized qualification. I tell you, losses, why Section 12 is the power to determine and to regulate and fix up the norms for training qualification.
Yes.
And 12A for determination for qualification for appointment of teachers.
Okay.
Yeah.
On this, you give us a short note.
And this is one thing. And other thing I tell you, losses, a person's have been brought within the zone of consideration, knowing well that he is on the date of notification is not eligible. That's why the rider, that 6 months bridge course, but it could have been otherwise, that there is already a course, a B.Ed qualified candidates have been made eligible to do a bridge course, then come at par with the other qualifications DLED, and you may be considered for selections. This was not done. If this was not done, under what provisions of law the notification can be issued? Can it be issued under Section 23? I'm putting a question to myself. When they doesn't have the minimum qualification, this notification is being issued with the intent to make them qualify. Isn't correct, your losses?
We don't know.
Otherwise, the 6 months bridge course, then the If there are insufficient DLED candidates, please, those who are B.Ed qualified, you can undergo 6 months bridge course, make yourself qualified and then apply. This is not the situation, Malab. Because bridge course was thought of in 2010-2011. Even then, Malab, there was no bridge course. Nobody has pointed out your losses. Am I clear to your losses? First bridge course 2010-2011 for 2 years because there was shortage of teachers. But that bridge course was also not introduced by NCT. Now, even 2018, you were thinking of bridge course and making them eligible. This is therefore, Malab, this is a notification to make someone eligible who are not otherwise eligible. Very eligible. But this is entirely rehearsed both the provisions.
Okay. Yes.
I think fair and fair for the state of West Bengal.
And one more thing, Malab, just I point out. Now, the 20, Malab, they are still going on the recruitment. Malab, I pointed out at the time of the motion stage. Now, as of today, it's a fiction of law. As of today, 28 June 2018 notification is not in the book.
State.
It's a pan-India notification. It's not in the book. But because this has been passed by the High Court in exercise of the power under section 226(2), your lordship has not granted any stay. So as of today, my lord, that notification is no longer valid unless your lordships interface with.
We'll have to examine. Yes.
In item 28.13, we are correspondent number 10, state of West
Who
Bengal.
are you supporting?
Our only request is this.
You're supporting B.Ed or bridge course?
It's totally in your lordship's hands, whatever your lordship decides. The state is only concerned with this, that pursuant to the 2018 notification, we conducted a recruitment drive and there are 16,500 teachers that are currently recruited. Because we have checked around 738 vacancies open because when this litigation started, we stopped the recruitment. But our request is the lordships may kindly, which whatever way your lordships takes a call, whether 2018 regime is upheld or 2010, may kindly not disturb this recruitment because otherwise it will have
That
a
will take into consideration.
yes, that's the only thing because otherwise it will have a disastrous effect on our infrastructure with regards to primary education.
So you are not taking B.Ed right now.
No, we had taken as per the 2018 notification. That
Going by 2018.
yes, because it was the extant law when the recruitment took place, so we had to follow that. We had to comply with that. But we have our recruitment took place during the 2018 regime. Because then now this Rajasthan judgment has come. Based on that, certain candidates went to Calcutta.
You don't want the added problem of primary education.
Yes, you are. Second. Lordship anyway is aware of the problems with private schools. Yes, Lordship. The only request is, Lakshman, can you disturb whatever is Lordship?
Yes,
As far as primary code is concerned, our stand is we are adopting the submission of the state. One. Second,
kindly give a composite note.
Item 27.
it's only one line.
Item 27. And this is also we are appearing on the 27.
I am appearing item number 28.11 and 28.12, my lord. I have sought submission, my lord.
28, 1, you are for.
I am for the petitioner, my lord.
You are?
I am for the petitioner. I have filed a writ petition in both the cases.
You are delayed or?
For the DLEDs. I am
You
appearing
are supporting the delayed cause.
Yes, my lord.
Okay. So, delayed cause has been extensively supported. Do you have anything to add?
Yes, my lord. One thing, my lord. What was the problem in which condition the?
Is there a shortage of?
Yes, my lord. I'm
Is there a shortage of delayed candidates in Bihar?
No, my lord. There is no shortage in Bihar, my lord. Neither in Uttar Pradesh, my lord. Well, I have filed the application for permission to file the additional document and in which the state government.
Same. Who is for the state?
Well, I am appearing for candidates of state of Punjab.
No.
For BSTC candidates.
Bihar rules for the state.
not issued notice
Notice has been served
directly.
Notice has been served.
Yes, Lord. I have filed the application for permission to file the additional document in which I have filed the order of the Patna High Court in which the state government filed a counter affidavit and accepted that the more than 12 lakh real candidates are available for the primary.
Okay, we'll record your submission that there are enough.
And the same condition in the Uttar Pradesh also more than 5 lakh people.
You kindly give us a short
And you are
Apply.
Well, I am appearing to the B.Ed candidates of state of Punjab.
Yes.
So I have moved an interim application for intervener. Lordship, in state of Punjab, there is no concept of bridge course. In state of Punjab, every B.Ed
B.Ed candidates first have to clear the eligibility test. Only then they can undertake the ETT test, Your Lordship. Your Lordship, the situation in Punjab is slightly different, Your Lordship. Now, why I am seeking this clarification is because after this Rajasthan High Court judgment, they knew it. But the state of Punjab,
I am appealing for
Detach this.
I would submit your lordship takes a view on Rajasthan and then post other things later and see how it.
Punjab will detach.
Lordship, this intervention application only in main Devesh Sharma case. Why I am seeking this clarification is because now state of Punjab has issued a notification after Rajasthan High Court judgment in which they have disqualified the B.Ed candidates. That petition is challenged before the High Court, but the High Court has stated that they will wait for the decision of my lord. Only then they will.
Yes. So there's no purpose now in looking.
Lordship, the eligibility test, prior eligibility test is there in Punjab.
We are applying for diploma holders
High
in the
Court
state of Punjab.
will wait for our decisions. Yes.
Yes, Mr. Prabhu.
May it please your Honor. I can only open by saying, perhaps this is the only court in the country where you can stand up and argue anything under the sun. Every other court will first ask you, what is the pleading? What is the case you are? Please confine yourself to the pleading.
It is our good. It is your
Here, anybody, and then this convenience compilation is the most wonderful thing.
Yeah.
You
It's not most inconvenient.
It is the most wonderful thing called a convenience compilation where anything, anyway. Having said it, my lord, let me just start.
If my learned friend has an objection
Let me
to the
first-
document, I will be able to
Lord,
show
let me-
from the record it was before the High Court.
Let me first start
Let
now
me just show
my
you
rejoinder.
once.
If they have not finished, they can go on. Now, let me start my rejoinder first by referring to a judgment of this court in PM Latha. Because orally it was said that our case is covered by two judgments of this court and one full bench of Bombay High Court. Now, let us see what the main of those three judgments actually says. And in my own words, I'm going to tell your lordship what it says.
Okay. PM Latha, what is the
PM Latha is
2003, volume 3, SCC 544.
2003, volume 3, SCC, page 541. It's in their convenience compilation. It is volume 3 at page 466.
Okay.
What is there?
Well, Lord, this is their trump card. This is the judgment which, according to them, says B.Ed is not eligible. This is their trump card. So,
Not in higher education.
so 2003, 3 SCC 541. Let me tell your lordship, this is that page.
It's a little strange.
400.
I want you to read these judgments, my lord.
Can I now
It's
have?
not necessary.
Can I have my rejoinder the way I want to have it, Lord, without any interjection? Yes.
Mr. Patwani, I'm addressing the court.
No, if there is a problem, we'll ask
If
you.
there's a
Yes.
problem, that's all they
Yes.
ask you to reserve that. That's it. Because I didn't read
But
it.
my friend will feel the necessity of getting that up many times because when I continue, but then she has to resist it. Page, my lord. Yes. Oh, yes.
Page.
Now, kindly have this judgment, my lord. What does this judgment say? This is a case. Yes. This judgment is orally stated to be a case which holds B.Ed to be ineligible for primary courses. Now, kindly see what it says. This is a judgment which came from the state of Kerala. In the state of Kerala, as per the rules in existence, B.Ed was not eligible to apply for primary classes. If your lordship will have page 4, the reported judgment at page 543, para 1. These appeals have been preferred by the candidates seeking recruitment to the post of lower primary, upper primary teacher in government schools in the state of Kerala. They questioned their non-selection to the post due to inclusion of B.Ed candidates in the...
What are you reading?
The very opening para of the judgment. It is, my lord, at page 468 of that compilation.
Yes, this page.
Yes. These appeals have been preferred by candidates seeking recruitment to the post of lower primary, upper primary teacher in government schools of the state of Kerala. They questioned their non-selection to the post due to inclusion of B.Ed candidates in the select list prepared by the Public Service Commission of the state of Kerala. Their contention before the High Court was that in the advertisement issued for recruitment to the post of teachers in government primary school, B.Ed is not the prescribed qualification and only candidates with prescribed educational qualification of teacher training certificate were entitled to compete for selection and seek appointment. So therefore, B.Ed was not the prescribed qualification in Kerala. In spite of that, B.Ed candidates were included in the select list. This was challenged. Learned single judge struck down their inclusion. Matter goes to the division bench. The division bench approves the view of the single bench that they were not eligible to compete. However, the government makes a statement that we are proposing to make them also eligible. And therefore, the division bench says, kindly have now page 469, para 3, second para. This is what happens before the division bench. The government has expressed in the affidavit, this is a para 3, the extracted para. The government has expressed in the affidavit dated 19 January 2000, they would frame rules in accordance with the decision taken on 2nd June 99 in consultation with the Public Service Commission for future appointment of teacher training hands only in lower primary school and B.Ed and TTC hand in upper primary school as expeditiously as possible. This is a solemn undertaking which should be implemented with extreme swiftness. We do not want to keep the position uncertain and vague insofar as future appointments are concerned. It is made clear that we have validated the appointment already made for different reason, etc. Then what the court division bench said was that the rank list published by Public Service Commission for appointment to the post of upper primary is valid. Direction given in the impugned judgment to rearrange the rank holders in so-and-so district and cancel the appointment of B.Ed holder is set aside. So what happened? Before the division bench, the government said we are going to amend the rules and make them also eligible. Division bench accepted it, said for lower primary you appoint as per single judge, upper primary they held up the process. That was then challenged by the diploma holders before this court. Your Lordship may kindly have now para 6 of the reported judgment. At page 470. Learned counsel, para 6. Learned counsel appearing for the appellant contends that when the terms of the advertisement quoted above are very clear to indicate that B.Ed degree is not the prescribed qualification, such candidates were clearly ineligible to compete and they could not have been allowed to take part in the selection test and be included in the select list. Learned counsel has relied upon so-and-so two judgments, etc. I need not refer to it. Then para 7, learned counsel appearing for the state of Kerala and the Public Service Commission. Some of the private respondents have qualification than TTC, and as in the process of recruitment of primary teachers in government schools, candidates with B.Ed were allowed to compete. The division bench was right in not upsetting the select list, etc. Then, my lord, para 8, State of Kerala Learned Council pointed out that pursuant to the directions of the division bench, Kerala education rules framed under the Kerala Education Act of 1958 have been amended for upper primary teachers. Now, along with TTC, B.Ed of recognized universities of Kerala has been prescribed as a qualification with effect from the date of notification. So, in Kerala also, from 2000, they made B.Ed as a prescribed qualification. Now, para 9 and 10 are very crucial, which answer the question before your lordships. Para 9. It is not disputed before us by the parties that the Kerala Education Act of 1958 and the Kerala Education Rule framed thereunder regulates recruitment to the post of teachers in private schools aided by the government. It is not brought to our notice that correspondingly the government memorandum or order which regulated recruitment to government primary school has been amended to prescribe B.Ed and equivalent degree as eligibility qualification. So your lordships find that there is no amendment in the rules so far to include B.Ed. Now then what your lordship says? Your lordship says, I'll read it and then I'll comment. We find absolutely no force in the argument advanced by the respondent that B.Ed qualification is a higher qualification than TTC and therefore the B.Ed candidate should be held to be eligible to compete for the post. On behalf of the appellant, it is pointed out before us that trained teacher certificate is given to teachers specifically trained to teach small children in primary classes, whereas for B.Ed degree, the training imparted is to students of classes above primary. B.Ed degree holders, therefore, cannot necessarily be held to be holding qualification suitable for appointment as teachers in the primary schools. Now, this was the argument. And now see the response. Whether for a particular post, the source of recruitment should be from candidates with TTC qualification or B.Ed qualification is a matter of recruitment policy. Please mark the word policy. We find sufficient logic and justification in the state prescribing qualification for the post of primary teacher as only TTC and not B.Ed. Whether B.Ed qualification can also be prescribed for primary teacher is a question to be considered by the authorities concerned, but we cannot consider B.Ed for the present vacancies advertised as eligible. I am very heavily relying on the last 10 lines of this paragraph. What your lordship said was whether a particular, just above placitum C, whether for a particular post, the source of recruitment should be from candidates with TTC qualification or B.Ed is a matter of recruitment policy. So it is a policy matter. Number two, we find sufficient logic and justification in the state prescribing qualification for the post of primary teacher as only TTC, not B.Ed. Good enough. They say we find logic, it could be done. But whether B.Ed can also be prescribed is a question to be considered by the authorities concerned. We cannot for the present consider them to be eligible. Having said so, what ultimately the court does in para 16, the all appointments of B.Ed are not disturbed. They are disturbed to the extent necessary to accommodate the writ petition.
That may not be relevant.
Yes,
Because
yes.
the relief ultimately is granted in so many factors.
So, my lord, I would respectfully submit in rejoinder that the debate before your lordships has been considerably widened to an extent which is not even necessary for the purpose of deciding these appeals. According to me, the focus is two issues were addressed by Dr. Singhvi. And those two issues are actually the crux of the matter. He first said that there is no power to issue such a direction with the central government. Under section 23(1) read with 35. I have to meet that point. That's according to, as I understood, that was his first argument. His second argument was NCTE has not applied its mind.
Well, under 35 directions can be issued only to the government.
I'm going to answer it. I have to answer that. I'm going to answer. So he first said that there is no power to issue such a direction with the central government under 23(1) read with 35. So let me answer that. And let me tell your lordships what simply this is shutting your eye to half the statute available. There are two statutes which have to be read in harmony with each other. What is 23(1)? 23(1) of the 2009 Act, and I already showed from the statement of objects and reasons, scope of 2009 Act and scope of 73 Act. 23(1) of the 2009 Act says, any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible. No regulation is required under this Act. You don't need NCTE to make a regulation for the purpose of this Act. Anyway, the regulation argument is answered in my favor by the Rajasthan High Court in para 42-43, and there is no appeal against that part of the judgment. I'll go to that a little later. So now let us interpret 23. So what does 23 say? Any person possessing minimum qualification as laid down by an academic authority. Now the academic authority could have been UGC, academic authority could have been AICTE, academic authority is NCTE. Now, how that academic authority is to exercise its powers will not come under this Act. It will necessarily be regulated by the Act under which the academic authority is constituted. So to say that the 29 of NCTE Act will not apply is completely erroneous in law is my respectful submission. That is the pleaded stand of NCTE in its special leave petition.
But Walia,
Yes.
corollary submission was made by Ms. Arora that even if NCTE, we accept that NCTE has an application in 23(1), the manner in which minimum qualification
I will come to that.
is laid down.
I'll come to that. She says regulation. I'll come to
Yes.
She says regulation. I'll come to that. I'm conscious of that.
Then 29(1), a parimaterial provision has been read in Bombay Port Act, whatever it
this. I'll tell your lordship what Bombay Port Trust judgment is. Bombay Port Trust had regulations. Those regulations said degree holders are eligible for appointment as assistant engineers. The government wanted to make diploma holders eligible. The government issued a directive under its power to issue directive saying diploma holders are also eligible. That directive was challenged. Para 16, 17, 23, 24, your lordships hold. And in the face of the regulation, such a directive could not be issued. Please have that judgment immediately, those two paras only. Then your lordship sees it at your lordship's leisure before your lordship finally takes a view. Just this is that judgment. If there had been no notification adding B.Ed in the 2010 notification, and the government had issued a directive to NCTE to make B.Ed people eligible, and NCTE had said yes, they are eligible by an executive order without notifying it, then the Port Trust judgment would apply. I hope I am clear in the distinction I am making. There are,
Are you trying to say because in Bombay Trust case there was nothing like 23(1)?
no, in Bombay Trust case, the basic regulation prescribing the qualification had not been amended. Without amending the regulation prescribing the qualification, a directive had been issued to make diploma holder eligible. Under the Bombay judgment, only degree holders were eligible under the statutory regulations for. Just take that judgment for 1 minute. Because we will have to read the judgment.
Page 568 in volume 3 of the compilation.
Just have that judgment.
Yes.
Just have, kindly take up para 5.
Page 571.
Actually, I'll read from para 3 because regulations are quoted in para 3 and 4. The Madras Port Trust employees appointment promotion regulations were made under Section 28 of the 1963 Act. May I pause here, my lord? If I can just explain to your lordships.
568. 570.
Shall I just, in my own words, again say what I am trying to say and then read
No,
the
we
judgment?
followed what you're trying to say. You are saying that the basic minimum regulation was not, qualification was not amended.
Correct.
Something else was
A directive was issued
Okay.
to make a diploma holder eligible without amending the regulation. So, to apply that analogy to the facts of our case, the 2010 notification lays down TTT, diploma, etc. eligible, B.Ed eligible for 2 years that under the relaxation clause. If without notifying a fresh notification as has been done in 14, a directive had been issued under 29 to include to make B.Ed eligible, then this judgment would have come to their aid. But here the difference is that directive is issued to the authority competent to make the regulation, NCT, and NCT has amended the regulation. So so therefore this judgment will not apply. The other argument that NCT has not applied its independent mind can be a separate issue which I will deal with. I hope I have made.
You're saying that in this case,
Correct.
the amendment, the direction was given straight away under the provision given in the residuary clause.
Correct. Without corresponding amending the regulation. The regulation still.
Without there being a notification in 23(1).
Correct.
In this case, it is
Correct. In this case, the directive went to the body competent to amend those, make that notification, and the body has made issued the notification.
so they followed the procedure.
Correct. So the only argument which possibly can be is they have not applied their mind.
No, but then this whole argument is dented to the extent that the counsel for NCT is saying we have done nothing. We got the order.
I will meet that. I have to meet that. That's the second point Dr. Singhvi made, and I have to meet it. I'm still on the first point. I will meet it. and there is, according to me, there is no merit in that submission. And I'll tell your lordship why when I come to it. Now, so therefore, just see now para 3 and 4, what this position is. The Madras Port Trust Employees Appointment Promotion Regulations 1977 were made under section 28 of the 1963 Act. 28 of 63 Act gives power to make regulation. Regulation is made. Same Act gives power to issue directive and policy. So the directive can't override a regulation. It's very simple. Regulation 5 read with the schedule provides that so far as appointment to the post of executive engineer is concerned, possession of a degree in civil engineering is imperative. And the direction was make diploma holder eligible. It was amended with the approval of the central government in terms of subsection 1 of 63 Act. Regulations have statutory force. They have been published in the Gazette. Not only approval of the central government was obtained, they also laid before both houses of parliament. Some of the employees were diploma holders. They formed an association known as Chennai Port Trust Diploma Holders Association. In view of the embargo placed by the regulations on their promotional prospects as the educational qualification for executive engineer, they made a representation.
See, we got your point.
So writ petition was filed, etc. Then directive was issued. Now just see this one paragraph, which really gives the crux of it. Just kindly see para 21, which is the crux of the whole matter.
The statutory regulations
Have not been amended. That's the whole point. So you can't issue a directive on a matter of policy which goes against the regulation. So this judgment cannot come to the rescue. This would have been a good judgment to rely on if there was no notification under 23(1) notifying the qualification. Says statutory regulations have not been amended. The central government, as noticed, does not have any power in regard thereto. Under the 63 Act, all authorities specified are statutory. They have to act within the four corners. The legal principle that administrative act must yield to a statute is no longer res integra. So it is an administrative direction. It has to yield to a statute. Now this is regarding this judgment. Now we're not coming back to 23. Now 23, so my argument on 23, but I need not labor and elaborate it too much. My argument on 23 is, just kindly see 23 with me once.
23, what you indicated just now, that NCT enters this 23(1) with all its trappings under.
Correct. Central government has authorized NCT. Once central government has authorized NCT, exercise of powers by NCT will have to be regulated by that act. This act doesn't tell us how NCT's powers are to be regulated. And tomorrow, central government can say UGC is the competent authority, hypothetically. Then we have to go to that act to see how UGC has to act. So, when the authority is given to NCT, how does NCT have to prescribe qualification? It has to prescribe it by a notification. If NCT makes a regulation under the NCT Act, it is of no help under this Act. Under this Act, it has to be a notification. So therefore, the whole argument of how regulation under that Act is framed is completely irrelevant in my respectful submission. Because 23(1) says, academic authority empowered by a notification has to prescribe qualification. Academic authority empowered has by notification prescribed qualification. And there is absolutely nothing wrong in it. Now, just kindly have this 2014 circular and 2 paragraphs of the High Court judgment. The 2014 notification says, what is the qualification? Qualification is as laid down in this August 10 notification, as amended from time to time. This has been amended, and that is precisely what the High Court records in para 42-43. Just kindly have these 2 paras of the High Court judgment, and they are not in challenge. They have not raised a challenge to that. How can they argue this in this court without challenging those findings?
should also get the.
So, just kindly see that notification. Yes, I should go a little.
Sir, those observations are in your favor.
Correct. This point is dealt with. Kindly a para 42-43. Just see para 43 straight away. Para 43. The learned counsel, Shri Vigyan Shah, was perhaps not correct in contending that NCTE could not have amended the eligibility criteria without amending the notification dated 12th April 14. This is the argument raised now. Under this notification, clause 4...
What they mean is without amending the regulation.
Correct.
Notification regulation.
They say that
Without amending the regulation.
they say that is not, this is also not a regulation actually. If your lordship will see this, this is also a notification. But they say this was placed before the parliament. So therefore they say,
In terms of 32 and 33.
so they say we will elevate it to the status of a regulation. I don't think that can be done. It after all remains a notification. Whether it has been placed before the parliament or not, it's not a regulation. And even this can be amended by the NCTE in the exercise of powers under 23(1). Because, but let us see in any case what, so just kindly see this notification. I mean, this notification actually, just see para 3.
Just a minute. What else is regulation? Because regulations are framed under 32. Power to make regulation and give it the powers are given to NCTE.
Those are not separately done. That's not a notification then. Then those are drafted separately, those are framed separately, and I'll just take your lordship.
How else will the regulation be framed? NCTE has framed the regulation, that is not in doubt.
Correct.
When NCTE has to frame regulation under 32, 33, these regulations have to be placed before the house, both the houses.
Correct.
So there is nothing wrong.
The council may, by notification in the official gazette, make regulations not inconsistent with the provisions of the Act, and the regulations made thereunder generally to carry out the provision of this Act. So that regulation will be quite different from a notification. A regulation then will have to necessarily follow the procedure of being laid before the parliament, etc.
That has been done.
In 14, it has been done. In all earlier or later notifications,
Earlier there was no requirement because there was no 12A.
correct.
There was no requirement. So our argument is that after 12A, it has to be done by regulation.
No, 12A here will not apply because 12A gives power to frame the educational qualifications by regulations. But when we are coming to the 2009 Act, the 9 Act says it is to be done by notification. Regulation is not required. Please see the 9 Act. We are ultimately, this notification now is being issued under 23(1) of the 2009 Act.
If your argument is
Then it is
NCTE enters 23(1) with all the paraphernalia of NCTE Act, then this becomes applicable.
Correct. So even if this doesn't change anything, because the regulation itself says what will be the qualification. Qualification will be what is prescribed in the 2010 notification as amended from time to time.
Change that by notification.
Please read serial number 3 with me.
See, what we are wondering, this regulation, notification of 12th November 2014, a minimum qualification has been prescribed.
Correct.
Now, in the event it is altered by a notification not following this channel, then the Potra's judgment will become applicable against you.
No, this regulation itself says what is to be done. Please read it. The regulation gives the power. And that has been discussed by the High Court and in Maurya also, both.
Okay, well,
Just read first schedule, serial number 3.
yes.
Minimum now it's just the title of the schedule. Level, minimum academic and professional qualification. Your Lordship got that one right at the top. Now for preschool it is given, preschool nursery it is given. Now primary and upper primary, classes 1 to 8. Minimum qualification as laid down by National Council for Teacher Education, vide its notification dated 23rd August 2010, as amended from time to time, issued in the exercise of powers conferred under 23(1) of the RTE Act. So this regulation itself has authorized NCTE to lay down the qualification by notification under the RTE Act.
Let us read what has been the Rajasthan High Court on this.
Yes, this is precisely what the High Court says. That the regulation itself empowers it. Yes. Para 43. The Learned Council, my lords have got it. The Learned Council, Shri Vigyan Shah, was, what else?
Yes.
My lord, this is both.
You carry on that.
All right. It's a little important.
161.
45,000.
Yes.
Yes.
The Learned Council, Shri Vigyan Shah, was perhaps not correct in contending that NCTE could not have amended the eligibility criteria without amending the notification dated 12th November 2014. Under this notification, Clause 4 provides for qualification for recruitment as provided in the schedule. The first schedule pertains to minimum academic and professional qualification at different level of schools. Clause 3 contained in the schedule pertains to primary and upper primary, class 1 to 8, and the qualification prescribed are minimum qualification as laid down by the National Council for Teacher Education, vide its notification dated 23rd August 2010, as amended from time to time in exercise of powers conferred by subsection 1 of section 23 of the Right to Free and Compulsory Education Act 2009. As per these regulations, thus, the essential qualification for appointment are those as prescribed under the notification under subsection 1 of section 23 of the Act, namely one dated 23/8/10 as amended from time to time. Thus, the moment the notification dated 23/8 is amended by NCTE in exercise of powers under subsection 1 of section 23, automatically such change gets reflected and embedded in the qualification prescribed in the first schedule of these regulations. Thereafter, there was no need to amend this notification. All challenges to the preliminary notification would automatically be, all changes, it should be changes or maybe challenges in the preliminary notification would automatically be recognized for the purpose of the said schedule. Now, this exact point was also raised in Ram Sharan Maurya. And in para 76 of Ram Sharan Maurya, just read that one para with me here. It says exactly the same. Volume 2. No, it's in IA 25803, para 76. Page. They have it. They have it. Page 48 of this. Para 76. There it is. Going
Yes, yes.
going by the parliamentary intent in empowering NCTE under the provisions of the NCTE Act and specific authorization in favor of NCTE under the said notification dated 31st of March 10, the authority of NCTE is beyond any doubt. Though there is no specific regulation as contemplated under section 32 read with 12 and 12A of the Act for the present purpose, by virtue of specific authorization under the notification dated 30th March 10, NCTE was entitled to lay down those holding qualification of Bachelor of Education as entitled in said notification are entitled to be appointed as teachers for classes 1 and 6. Would be binding. It is for this reason that the GO dated 1st December 18 notifying ART clearly stated that candidates possessing minimum qualifications specified, including one of 18, were entitled to participate in ARTE 19. And in fact, not only this PF, there have been various changes made, some relaxations done. They are all under notifications. There is no regulation framed by NCTE so far as the RTE Act is concerned for appointment in primary schools. So therefore, even practice shows that this is how it is being done and this is what the regulations state. So my respectful submission on the first point is that in fact the power of the central government is very clear under section 29. The moment NCTE is appointed as the authority to lay down the qualification, its powers will have to be seen under the Parent Act constituting the NCTE. Section 29 is a provision which authorizes the central government to do so. Now, interestingly, when Mr. Sibbal was criticizing the note of the minister, a query came from your lordships that he can do it. And then Mr. Sibbal said, no, this is not a day-to-day matter. This affects thousands of students all over the country. He said millions. He said millions of students all over the country. So the moment it is accepted that this is not a day-to-day decision, affecting large number of students all over the country, then under 29, it becomes a matter of policy. It becomes a matter of policy for the central government to be concerned and to issue a mandate to the NCTE. And therefore, the action of the central government in issuing a mandate cannot be faulted. Now the next issue is, they say NCTE has not applied its mind. There is no pleading. NCTE has not said anywhere we have applied our independent mind. Not before we look for answers, we must search for the correct question. I have seen the full writ petition filed. There is not a whisper that this is not an independent mind. They never probably even knew at that time the procedure. They went under the RTI.
NCTE has said that as per direction of the government.
What NCTE has said, I'm going to read to your lordships just now to substantiate this. Now, they have, now just see the judgment with me. 2 or 3 small issues and 1 or 2 letters, because that's all that we have here. Just kindly see the judgment. Just one line in the judgment. The whole thing starts in contemporaneously in April of 2018. Now, after April 2018, there is one very important letter written by the NCTE, which I have found from the convenience compilation filed by my learned friends. Kindly have volume 1 at page 123. Volume 1 at 123. Page 123. Convenience compilation, volume 1, 123. Now, this letter is written by Mr. Sanjay Awasthi, who is the member secretary of the NCT. It is dated 23rd May 2018. It says, please refer to your letter dated 12th April 2018. Now, this 12th April letter, in fact, lordship will see, this process had started sometime on 9th April. If your lordship will just note here, page 143, para 18 of the judgment. The first meeting was held on 9th April, not first but one of the many meetings. Just have page 143, para 18. So it's an ongoing process. Just see this para 18, first, fourth, fifth line. Again, my lords, host has got that?
No.
Page 143, just kindly have judgment at page 143.
Yes.
Correct?
Yes. Let's carry on.
Now, para 18, again through means of RTI, petitioners have sought further information regarding deliberations which took place before the impugned amendments were notified. Along with an order dated 28th October, the appellate authority under the RTI Act provided certain internal document. One of them were the minutes of the meeting dated 9th April 18 of the officials of the MHRD. Then, my lord, I need not read further. Now, in this background, kindly have this page 123 letter.
You mean to say it started in April?
Much earlier, 16. It started in 2016. In my written note, we'll just put all those dates together. Now I have this page 123 letter. Please refer to your letter, page 23rd May 18. Please refer to your letter dated 12th April 18, bearing request for recruiting primary teacher with higher qualification, that is BA, BSc, B.Ed plus TET. It is further stated that MHRD may consider implementing the direction in the detailed noting of Honorable Minister of Human Resource Development. Now that noting of the Minister is sometime in April, in fact. 11th April. I am grateful to my friend. So it is 11th April. May consider implementing the directions in the detailed noting of the Honorable Minister of Human Resource Development. It may be ensured that the relevant requirements for teaching primary classes are fulfilled before 31st March 19. Now the member secretary is writing this letter. He is not individually authorized to do it unless the NCT has authorized it. 11th is the minister's noting. The letter goes on 11th. 9th was the first meeting. 11th is the noting. Letter goes on 11th. Reply comes on 23rd May. 28th May they have another meeting. And 30th May the directive is issued. Now kindly see what happens on 28th.
You're trying to say that there was some thinking of it.
Correct. What I'm trying to say is, member secretary can't write a letter without any authority of the body. If the member secretary is writing that, please do it. Now just see what he is writing. What he says is, please refer to your letter dated 12th April 18, bearing request for recruiting primary teacher with higher qualification. It is stated that MHRD may consider the direction in the detailed noting of the minister. The minister said, please make B.Ed eligible, which was criticized by my learned senior colleague, Mr. Sibbal Malot. I don't agree with that criticism, but then I will endeavor to show that it's a very valid noting, and if the minister is not to make it, when meetings are taking place, ultimately under the rules of business, who has to decide? The minister has to decide. So he took he decides, saying in the government that please do it. It goes to NCT on 11th April itself. That's the letter, 12th April, sorry. It goes to NCT.
Precisely, but they're saying he assumes the role of academic body.
No, he does not. He has the authority to issue a directive. He does not issue a directive on day one. He calls a meeting. He says, look, I feel like this. A letter goes to the NCT. Now NCT's response comes on 23rd May. Now are we going to say, and there is a general principle of law, every act of a lawful body is assumed to be done legally and valid. You cannot start with a presumption that this did not happen, or that did not happen, or they did not meet. Who knows NCT whether the entire body meets or they have a subcommittee which may have met. An expert committee may have met. Now, so therefore to say that there is no deliberation, there is no thinking, under 226, the court has not gone into it. I'm good. Court has not gone into it. They want your lordships to record a finding that there is no application of mind by NCT. But I say the materials are lacking. You can't pick up because NCT's defense is weak. Therefore, you can't reach a conclusion that therefore the opposite is true. Please see this letter. It says on 11th, you sent us a letter, 12th April, and minister's note we have seen. Please implement that note. But ensure that they are qualified by such and such date. Now, please see the 28th May meeting. That's very crucial. That is at page 145. So that lot of things are said there.
You mean to say if the concerned ministry says that a PhD in education is qualified, and then they say yes, all right, we do it. Fine.
But I don't think that the
PhD definitely higher.
I don't think, Lord,
If B.Ed is higher, PhD is even higher.
I am
So
responding.
now the thing is that High Court has not gone into this. That's the whole problem.
So, Lord, I say that there is no material for your lordships also to return such a finding.
No, there are rulings to this effect. And what's so great in it, a diploma course in primary education is designed for teachers training to so that they can teach primary. These are the formative years. It is not qualified. It's not higher. Definitely it is not higher. Even if there would have been no judgment, it's not higher.
So, I am not even arguing it is higher. I am not saying
If
it
you are defending that, it's
Yes. So, I am saying it is a qualification which was eligible for
a
recruitment.
different qualification.
Yes.
Education.
My submission is it is a qualification which was eligible for appointment in primary schools right up to 2012. It is only after 2012 that the acts fell on this qualification. From 16, then this thinking started. Ultimately, in 18, they said it is eligible. Now, there is another subsequent notification also, which I am going to show to your lordships, which also says something. But just kindly see this 28th May note. So, for somebody, now it has been repeatedly said, sir,
Why is it? What the problem with us is this. See, the problem there is that here directions have been given not by anybody else but by the minister. So he is the main person in this hierarchy. And he says that this has been done. Now the problem with you is that a diploma holder has done his training 1 year, 2 year, whatever it is called. Somewhere it is called certificate, somewhere it's called diploma. Only to teach primary education. He cannot teach in the higher secondary. B.Ed is for secondary and higher secondary level. Now, when a diploma teacher cannot teach in the higher secondary, how can you make a secondary eligible to diploma?
now kindly see two things.
And particularly in a state where there are so many diploma holders.
Now, diploma holder is entitled to teach higher also. That is the 23rd August notification itself.
Higher than primary.
Yes. Kindly see that.
Must be higher.
No. Just diploma. For classes, same classes 6 to 8. Kindly see page 195.
That is also primary. It's about primary.
No. That is primary, higher primary.
It's elementary. Let's call it elementary education. Article 21A speaks of elementary education. 1 to 8.
No, that is 1 to 5. Elementary.
They say 1 to 8.
So 1 to 5 he is eligible. They said that sir, we are only eligible for 1 to 5. Today they are conceding that no, now 1 to 8 also I am eligible.
This advertisement was
so-
1 to 5.
notification, which was for in primary schools right up to 2012. It is only after 2012 that the acts fell on this qualification. From 16, from 16, then this thinking started. Ultimately, in 18, they said it is eligible. Qualification also, which I'm going to show to your lordships, which also says something. But just kindly see this 28th May, no. So for somebody, now it has been repeatedly said, sir,
Why is it? But the problem with us is this one. See, the problem there is that here directions have been given not by anybody else but by the ministers. You see, the main person in this hierarchy, and he says that this has been done. Now the problem with you is that a diploma holder has done his training 1 year, 2 year, wherever, whatever it is called. Somewhere it is called certificate, somewhere it's called diploma. Only to teach primary education. He cannot teach in the higher secondary. B.Ed is for secondary and higher secondary level. Now when a diploma teacher cannot teach in the higher secondary, how can you make a secondary eligible to diploma?
now kindly see two things.
And particularly in a state where there are so many diploma holders.
Now, diploma holder is entitled to teach higher also. That is the 23rd August notification itself.
Higher than primary.
Yes, yes. Kindly see that. Kindly see that.
Must be higher.
No. Just diploma. For classes, same classes 6 to 8. Kindly see page 195.
That is also primary. It's above primary.
No. That is primary, higher primary.
It's elementary. Let's call it elementary education. Article 21A speaks of elementary education. 1 to 8.
No, that is 1 to 5. Elementary.
They say 1 to 8.
So 1 to 5 he is eligible. They said that sir, we are only eligible for 1 to 5. No, today they are conceding that no, now 1 to 8 also I am eligible.
This advertisement was for 1 to 5.
Lord, I can conclude. Rest we can give written submissions then. I can conclude in 5 minutes. I just show those.
Just in terms of section 29, if your lordships may grant me the liberty to just...
So there can't be a sir rejoinder now, Lord.
Judgments of the DDA Act as well as...
No, there can't be a sir rejoinder now.
The state government and central...
There cannot be a sir
directive for you. Because I'm appealing for some of the respondents to look in item 28.10.
No, there cannot be a sir rejoinder. It will never finish like this.
No, we will not permit.
No, he's only placing judgment on the aspect of
Whatever is the note, you give a collective note from one side.
All right, just give me 2 minutes to show those sufficiency of students, and then I'm done. I'll make a note and give it to your lordships. Yes.
Put it down either note 10 minutes minimum to show some points on facts and even on the law.
Madam, you have argued and
We
We have noted your argument.
those factual aspects. I need 5 minutes, not time.
Patwali has gone beyond
Your only argument is that whatever central government tells us to do, we do that.
which has been whatever is the Patwali has said.
It's time to go to section 29.
NCT has changed its state there.
This is not a free for all that everyone can get up and say anything.
So, but Patwali have finished.
Yeah, just give me 2 minutes more and I'm finishing. Just see page 145.
145 of
The paper book.
My lords may then keep it tomorrow because my learned friend has
Just hold on for a moment.
statements.
We have to rebut some of them.
No, then we will rebut their rebuttal. It will never finish. Lord.
we can't.
Yes.
Tomorrow, Madam, this is just a request. If the can be given, this side can be given 5 to 10 minutes after Madam's finishing of the board.
See, if you continue like this, we will release.
Very well.
We will release this matter. You are going on.
We are 9, 10
Don't do this. Let them finish.
My lords is once.
Please, madam, just a minute.
Very well.
You finish, Mr. Patwali, then we
Let us finish.
finish whatever you are.
page 146. Now, what I want to point out here is para 3 at the top. This is the 28th May meeting. The matter was again discussed and deliberated in detail in the meeting held today. Your Lordship has that? 28th May, chaired by the HRM, the Minister, attended by the Special Secretary, the Chairperson of NCTE, Member Secretary of NCTE, Joint Secretary KVS Commissioner. KVS Commissioner raised the post of primary teachers, raised the issue of, now this is very important, KVS Commissioner raised the issue of insufficient number of candidates applying for the post of primary teacher and candidate applying from few states across the country. It was informed, please mark this line, by Member Secretary NCTE that approximately 7.5 lakh seats are available for DED across the country, out of which 50% are filled. However, TET pass DED candidates would be much less as the result of TET varies from 6 to 16%. This makes availability of eligible DET candidate much less than the desired.
What does it mean? How are the TET pass candidates would be much less?
They have to pass TET to be appointed. Now, out of the total number of candidates who have DET, experience has shown only 6 to 16% can pass.
Yes.
So 84% to 94% of them don't even pass. Now, it is said with a flourish by all counsel by reading one line in the Rajasthan judgment. Sir, there were 3.5 lakh people available.
Even a B.Ed qualified has to pass this.
Correct. So those are available.
We don't have any data before us that the B.Ed candidate 100% pass.
No, you know, with the B.Ed candidates coming, the number becomes
More persons to fail.
there are far more people available. Now on vacancies, it was said with a flourish that please read this one line in Rajasthan. There were 3 lakh candidates available against 30,000 vacancies. Now what happens? When the post is advertised, the same group of people apply in all the states. They are the same 3.5 lakh going from state to state. Now the best proof of the pudding is in its eating. Please have one page of one IA which I have filed.
We make a rough calculation. In Rajasthan, they say more than 3 lakh diploma candidates are available and the posts are 19,000.
Correct.
Even if we take it 6%,
Correct.
then 6% will be going to be more than 90,000.
Just
Roughly 90,000.
Just have IA 61541. After the selection process is over, the Rajasthan government finds that there are candidates not available for almost all posts. Now kindly see page 7 of this IA.
What is this?
This is an application.
We have been served just now.
No, this has been served. I have proof. My email. Now kindly have page 7.
Yes. That's it.
Kindly have page 7 of this. Just one page and I'm done. Then I'll give the rest in writing. On students also. Page 7. Page 7. This is a letter from the Office of the Director Elementary Education, State of Rajasthan. Waiting list for cut-off marks in Rajasthan Elementary and Higher Primary School teacher recruitment. Kindly turn over the next page.
18 by not this recruitment is of 18.
Yes, of 18. Just see the number of posts. For unreserved posts, there are no candidates available. For scheduled caste, there are no candidates available. So in my note, my lord, I will give to your lordships. This is Rajasthan. In Uttar Pradesh, what happened? In UP, this B.Ed was made eligible because they advertised 68,000 vacancies. Only 41,000 could be filled up. Then in the second part of the process, they made B.Ed eligible. Only then they got sufficient number of people. And 19 states in the country have made B.Ed eligible. 19. And they are being recruited with this bridge course. So lakhs of B.Ed candidates have been appointed. They said bridge course is not even started. They are woefully wrong. In Bihar, the bridge course has started. In Madhya Pradesh, bridge course has already started. People have passed out and got certificates.
it's not. You should presume that we
Only one.
factoring the aspect.
If they stayed before the Patna High Court, I would do the
So in your note, you give that.
Then the SLP filed by NCT. Just one important fact. The NCT has placed the writ petition on record filed before the Rajasthan High Court where the general body meetings of NCT were placed date from 11th April 2016. That it was not even the agenda in any of the meetings.
Then give it in your note.
My lords, the point is this, that my learned colleague on the other side made random statements that this is not a part of pleading before the High Court. The fact remains that each aspect was pleaded and it was showed that there was not even an agenda to discuss this
You
relaxation.
can write that in your note.
Very, very great.
By Monday?
No, Monday, no.
By Monday we'll submit our written.
Without another date.
Yes.
हमारा next, I wonder to give 4-5 days.